Your Honor, as shown by the employment records that were provided throughout the case, Irene Hare has been an employee for my company for 20 years. The incident in question took place on April 25th, 2005, when the appellee suffered a left knee injury while working her shift as a nurse. I, Wesley Engle, am here today representing my client, Beverly Healthcare, an American Home Assurance Company, to defend my client's appeal of having to pay workers' compensation benefits to Ms. Hare. The goal of this appeal is to prove that even though Ms. Hare's injury occurred while she was working, it was not the result of work-related activities. I will present evidence throughout this case that support this claim and show why my client should not be held accountable for this incident. The types of evidence that will be utilized in this appeal include photographs of the appellee, incident reports, witness statements, doctor's evaluations, and medical records of the appellee. As shown by the appellee's medical records, it is a known fact that Ms. Hare has suffered multiple injuries to her left leg, which have required a number of different operations and surgeries. It should be noted that none of these previous leg injuries occurred while Mrs. Hare was working at my client's facility. My client has always worked with Mrs. Hare throughout these injuries and has allowed her to take time off and recover and heal as do fit. However, after analyzing all of the evidence in this case, we believe that the April 25th, 2005 injury to Ms. Hare resulted from these prior injuries and pre-existing conditions that the appellee possesses. Based on these findings, we believe that this injury was not work-related and could have been the result of normal daily activities. Thank you for your time, Your Honor. Now we will refer to Exhibit A, which is a photograph of Mrs. Hare on the day of the injury. She was using a walker on the day of the injury to assist her while working. And according to her co-workers' witness statements, they had never seen her use a walker or any type of other walking assistance while at work. So this may implicate her of being priorly injured before coming to work. Referred to Exhibit B, this photo shows Mrs. Hare wearing an ACE bandage on the day of the injury, which her coworkers said that they had never seen her wear an ACE bandage before, and this testimony can be confirmed in the witness statement given by her coworkers. Now we'll refer to Exhibit C, which shows Mrs. Hare smoking a cigarette. She was a long-time smoker. She had been smoking since she was 14 years old and would often take smoke breaks with her coworkers. Smoking is known to decrease bone health and increase the time that it takes for a bone to fully heal, which contributes to why Ms. Hare has had so many leg injuries throughout her life. Now referred to Exhibit D, this photo shows Mrs. Hare walking the day of the incident. She was always known to walk with a limp due to her prior leg injuries, but according to witness statements from her coworkers, on the day of the incident, she was walking with more of a defined limp, which may show that the damage was already done before she had come to work. Now referred to Exhibit E, this photo shows Mrs. Hare after the injury had occurred. Here you can see she's leaning against the nurse's cart, but according to her testimony, she fell to the ground because the pain was so great and she couldn't hold herself up. This photo contradicts her statement and shows that what she said was not entirely true. Now on to the first piece of evidence, which is an incident report given by Megan Pinnell, who was a co-worker that worked with Mrs. Hare. The second piece of evidence being a witness statement that was given by Nita Kirk, who was also a co-worker that was present at the time of the injury. And her testimony contradicts what Mrs. Hare had to say happened on that day. The third piece of evidence being a return to work doctor evaluation form from one of Ms. Hare's previous injuries, and her personal doctor, Dr. Charles Taylor, said that she only needed to work 4 days a week due to the damage that had been done to her leg throughout the years. And as we know, this injury occurred when Ms. Hare was working for her 6th day in a row. Fourth piece of evidence being a review of the appellee's medical history that was conducted by Dr. Guy T. Vise, Jr. The review of her medical history shows that throughout her life, she has suffered 2 pelvic fractures, 2 fractures of the shaft of the femur, a condylar fracture of the distal femoral metaphysis, 2 fractures of the patella from crushing injuries, 2 fractures of the ankle, and a fracture of the foot. She was also found to have these pre-existing conditions: osteoporosis, long-term addiction to nicotine, significant arthritis of the left knee, and severe weakness of the leg muscles. Fifth piece of evidence being the findings from the appellee's medical records review, which states that the injury that occurred on April 25th, 2005 was the result of a spontaneous fracture that had been just waiting to happen. Due to all of the amounts of surgeries that Ms. Hare has went through during her life, the bone was considered to be a diseased bone that could have been injured at any time. So it was not related to work and could have happened during her normal daily activities. Your Honor, after reviewing the evidence brought forward by my client and myself, Beverly Healthcare and American Home Assurance Company, I would ask that you rule in favor of our appeal. Even though the appellee's defense has brought forth evidence, I do not believe that their evidence shows enough proof to support their claim that the April 25th, 2005 injury to Ms. Hare was caused by work-related activities. The appellee's evidence fails to account for the multiple injuries, procedures, and surgeries to the left leg of Ms. Hare that have happened throughout her life. The appellee's evidence also fails to account for the number of different pre-existing conditions that Ms. Hare has that contribute to the bad health of her bones. The combination of these factors has to be accounted for when assessing the injury that Ms. Hare sustained on April 25th, 2005. While we understand that the injury occurred during work hours, we should not be held accountable for this injury because of the evidence that has been presented in this trial. Based on the evidence, it has been proven that Mrs. Hare's injury was not caused by work-related activities, but rather caused by her long history of injuries and surgeries to the left leg. This injury could have happened while Ms. Hare was performing normal daily activity. Therefore, my client should not bear the burden of having to cover this injury. There has been no valid proof to show that Ms. Hare's injury was caused by work-related activities, so I ask that you rule in favor of my client. By ruling in my client's favor, it will show that employers are not just insurers or guarantors for all employees who suffer untoward injuries while on the job. Thank you for your time, Your Honor. I appreciate it.